Welcome back to Real Estate 101. Today we're going to continue our discussion on family law and talk about cottages and divorce. And I'm pleased to be joined once again by John Schuman, Devry Smith Frank. John, welcome back to the show.
It's good to be back, Joe.
All right, John. So I've heard that some people who have cottages, especially cottages that have been in families for generations, some of those people are worried about getting married and then getting divorced and having their ex-spouse or ex-partner getting their hands on that cottage. I guess my question would be, is that, let's say somebody has a cottage in their family before they get married. Does that automatically become property that's divided at divorce?
It does, yes, if you own the cottage. And there's three ways that happens. The first is that it is, if it's a cottage and you use it together as a family, that becomes a matrimonial home if you're married. The second is that if it's a matrimonial home as well, then your spouse is entitled to use it after separation and a period from separation until divorce. And the third is that if your spouse puts a lot of contributions into the cottage, then they can actually claim an ownership interest in the cottage. And in those three ways, they can sort of get their hands onto the cottage.
Okay, so you mentioned matrimonial home. I thought you were only allowed to have one. Like, isn't your principal residence your matrimonial home?
No, you can have as many matrimonial homes as you have homes. It's any home that you occupy together as a family or you occupy together as husband and wife can be a matrimonial home. So it's not just your main home, unless you put a designation on title, then it can be just your main home. Otherwise, it is any home that you live together as husband and wife, and that can include cottage, your main home, your cottage, your timeshare down south.
Your second property.
That's right.
Right. So I guess for tax purposes, your primary home would be considered your principal residence. For family law purposes, your matrimonial home would be any residence where you live together.
That's right. And all the residences where you live together.
All right. So you also mentioned that the ex-spouse may possibly have the opportunity to use the cottage after separation. How does that work?
So if you're married and you use the cottage together while you are family, so it's a matrimonial home, then under Ontario's Family Law Act, both spouses have equal right to occupy a matrimonial home. That includes all your matrimonial homes. So your spouse has the same rights as you do to be at the cottage or use the cottage. So that's after separation. So you want to go up there, they're also entitled to go up there, even though you're separated. And they're also entitled to use the stuff that's there while you're separated and not yet divorced. And that continues until you either are divorced or there's a court order or agreement that says that they're no longer to go up there.
All right. So can one spouse lose ownership of a cottage to an ex-spouse entirely?
Not easily under Ontario's family law. The way that works is, or the way property division works in Ontario family law, is that you share in the value of assets. You don't actually share in the assets themselves.
Right.
So you don't get, by marrying someone, you don't get ownership in their assets. But if your cottage is a matrimonial home and it's not otherwise protected against being a matrimonial home, then the full value goes in as into your calculation of your property. So even if you inherited it or you had it before you married, the entire value goes into your net family property, and that's the property you're supposed to be divided, and your spouse is entitled to half of that. If you can't afford to pay out your spouse, then to make the big payment that you have to make as a result of having maybe two matrimonial homes on your side,
right,
then you may have to sell the cottage or sell something else, and then your spouse could say, no, I'll buy it instead, and they could get their hands on it that way. But under Ontario's Family Law Act, there's no direct way for them to get a ownership interest in a cottage or any other property just by virtue of being married to you.
Right, so they just share in the value.
They just share in the value, and common law couples don't share in the value, so that's not a consideration if you're common law.
All right, so is there any scenario where a spouse can unwillingly give ownership of the cottage away to an ex-spouse?
There is, and this actually applies a lot to cottages. Although there's no recourse under Ontario's Family Law Act to get ownership in property, there's these other well, they're not laws, it's called the principles of equity. And they're really complicated, and so this is where lawyers come in. But the ideas behind the principles of equity is that if a spouse or anyone puts a lot of effort or a lot of money into a property with the expectation they're going to benefit from it, then they should get something for doing that. If they don't get something for all the effort they put in, then the other side is what's called unjustly enriched.
Enriched, right.
And so what courts will do when someone puts a lot of their own money or a lot of their own effort into a property is they'll give them an ownership in that property to correct for that unjust enrichment or that unfairness. And you can see that happening a lot with cottages. So and this applies even whether you're married or not, but if you go up to your cottage and your spouse goes up with you and your spouse puts on a deck or builds the dock or, does the stuff you do at cottages, like cuts the grass all the time, fixes the roof, puts in a barbecue, chases the rats out in the spring, all that sort of stuff.
They're also contributing to the value.
They're contributing to the value. And if what they put into the cottage is less than they would have paid to just to go up there, like if they were going to rent it, then they get a value interest. And that's the way most people run their cottages, right? Most people, cottages are money losing endeavors for the most part, right? So most people put more effort and more money into them than they get out of them. So if your spouse puts in, like, they built the deck, they built the dock, they cleaned up the brush around the side, and then you separate from them and say, well, wait, I put a lot of that in because that was our cottage, not just your cottage. And then the court may give them an ownership interest in your cottage. And that applies whether you're married or not. So that's a real consideration when you're going up with a spouse as to what they're doing at your cottage and whether they're actually helping you increase the value or maintain the value of your cottage.
Okay, so here's another question for you. Is there any way where one spouse, let's say there's one spouse, two people are splitting up, can one spouse, if they don't want the other person or other spouse, ex-spouse, to use the cottage or even share in the value, is that possible at all in any way?
It is. And
let's say in the scenario where somebody bought the cottage before they got married.
Yes.
And they don't want that person to share in the value of the cottage after the separation. Is that possible?
Yes. There are a few ways of doing that. One way to do it is that you designate your main principal residence as being your matrimonial home. So you go to a real estate lawyer, your spouse has to go to a separate real estate lawyer, and you put a designation and title that says that your house in the city, that's your matrimonial home. And when you put that designation onto title, then every other property that you own ceases to be a matrimonial home. So it's just that one that is divided that way. So that's one way of doing it. That still doesn't protect you against, what happens if your spouse, does a lot of work at the cottage. The more sort of ironclad way to protect is to get a marriage contract or cohabitation agreement. The cohabitation agreement applies if you're not getting married, it's just your common law.
Right.
Because you can say in a marriage contract that cottage is always going to be yours and your spouse is never going to have a claim to it.
It's off limits.
It's off limits.
Right.
They can use it, but they can't have any claim to it. Now, you can't, if you have a marriage contract, you cannot prevent your spouse from using the cottage if you were married after you separated. You can only do that with the designation, but with the designation, you can't keep them from claiming an ownership in the cottage when they put a lot of effort into the cottage. So you need a combination of both usually to fully protect the cottage.
Okay, so you touched on one person doing work in the cottage that obviously helps increase the value of the cottage. So is there any way, let's say somebody puts in work into this cottage, is there any way from keeping them from sharing in the value increase in that cottage, even though they put in the work?
Yeah, so that's what you do with a contract, either a marriage contract or a cohabitation agreement, because marriage contracts and cohabitation agreements can specifically say that no matter what you put into the cottage, you're not getting interest out of it. It's off limits. And that's the only way of doing that. But
the other party's got to agree to this.
The other party has to agree
at the
to
outset and sign something, right?
Yes. The other way you can do it, and you have to keep records of this, is you can pay them for the work they did, right? So if your spouse is like, I don't know, putting the dock is a common one. So
right.
They do the dock, and you say, well, I'm going to pay you $500 because otherwise the guy down the road would have charged me $500 to put it in. So here's $500 for doing it. If you do that, then they got paid for the work they did.
Right.
So you can do, and they can do without having them necessarily agree and sign a contract too. But the most ironclad way is to have the contract, because they can if you pay them in cash, and you have to make sure you don't pay them in cash, you have to make sure you kept records. If they say they didn't get the money, then they say you were unjustly rich because you got something for nothing.
Right.
So you would need to keep records of the payment and the fact they kept the payment, and if you didn't have a contract instead.
All right. So What about the stuff in the cottage? Because you don't just have a cottage. Most people, you buy a cottage, you furnish it, yada, yada, yada. What about that stuff inside the cottage, the property?
So the way the Family Law Act works is it said when it goes to a matrimonial home, is that it is not just the home, but the contents that you have to share. So you bring in a cottage, you bring in a boat, you bring in a fancy barbecue, all that stuff. That is all stuff that is part of the cottage, and it would all be shared in net family property if you don't have a contract or you don't designate another property as a matrimonial home at the end. With regard to if you're not married, you don't have the right to that equalization issue, but you can have the same right to a piece of property. So if instead of having a cottage, you have a sailboat, and your spouse puts in, like, they scrub the hull and they put it in, they do the rigging every year, and they do all the excessive amount of work you have to do if you own a sailboat, and they do that, then they would, and they don't get paid for it, you don't pay them for it, then they could claim that they have an ownership interest in that boat. So, and that could apply to any boat or any object.
Any real property.
Well, any real property or any not real property. So any, like a boat, a table, antiques, all that sort of stuff, that could all be included in that sort of thing. That's right.
Right.
The only sort of limitation on that is after you separate and you're going to make one of those claims, you only have 2 years to make it. And once those 2 years are up, your spouse can't make a claim towards those sorts of assets anymore. So it's a quicker time for them to make a claim and come after you for them, but they still can claim a right to anything they've contributed to and that has enriched you as a result of their contributions.
All right. So let's say your intent when you bought the cottage was to leave something behind for your kids, whether it's the cottage or some of the stuff that's, in the cottage. Can an ex-spouse just take that away? If that was your intent going in?
So often when you separate, and if you especially have a lot of stuff put aside for your kids, your spouse will get suspicious as to whether or not you were just saying that to keep stuff away from them. And they get really suspicious if you put that stuff or designate that stuff for your kids in like the year or two before you separate, because then it looks like they knew the separation was coming and you're trying to get it.
Cover your tracks.
Yeah, right. And give it to your kids rather than to them.
Right.
So, but the way you have to protect that for your kids is you actually have to set up a trust. And you have to actually give it to your kids, because if your kids are minors, they can't own it themselves. They can't own real property, like actual piece of land themselves. So you have to put it into a trust. And that trust has to be a trust, a real trust that is properly set up, where the property actually becomes the property of the trust until it becomes a property of the kids, and you cannot get it back. And so that's the only way to sort of make sure your kids get it, is to create one of those. And to do that, you need to see a trust or a lawyer or an estates lawyer who can set up a proper trust to put the cottage properly in your kids' names. And so you can't get it back. You and your spouse can't get it back.
So if you do set up a trust, there's no way of getting in the way of passing that on to your kids.
That's right, because then it becomes your kid's property, essentially. Right. But you have to set it up so it's equal for you. It's not your spouse's, and it's also not yours. Not yours. Because if it could be yours, it could get divided again.
If it could be yours, it could also be theirs.
That's right.
Right. So I guess the whole thing here is, if the intent was there to pass it on to the kids, then you would have set it up the right way from the first time, and then it's hands off for everybody.
That's right. And that's what you want to do. You want to make sure you do it properly, because obviously if the cottage is going up in value like they have lately, then your spouse may really want to get that if there's a lot of money involved. And so you want to make sure it's set up properly.
All right. So what should people do for those that are possibly inheriting a cottage or even acquiring a cottage with a spouse or common law partner?
Well, they should get a contract say see a lawyer and get a contract and do the proper either designation on title or a trust to make sure that everything goes the way they expect it. And when both sides do that, and they both sides see their lawyer and they do the agreement properly, they both know what they expect. They both know what's going to happen at the end of the relationship if there is one, and there's no surprises. And the cottage is protected for whatever the intention is, whether it's to give it to your kids or keep it for yourself or keep it for your siblings. It stays that way if you have a properly done contract that you've done with a lawyer.
Okay, John. So is there any way that one spouse can buy out another spouse?
Yeah. So if your spouse has succeeded in their claim to either with an equalization claim, including the house in your net family property or the cottage in your net family property, and if they've made that claim in equity they've talked about and gotten a judge to give them an interest in that claim, then the only way you can do is you have to buy out their interest or buy out the equalization payment. It means you have to come up with the money to buy out the cottage that you thought you owned before.
All right, John, great stuff. Thanks for coming on today's show.
It's great to be here again, Joe.
So there you have it. If you're looking for a top family lawyer, get in contact with John Schuman of Devry Smith Frank LLP. Don't forget to subscribe to our YouTube channel, comment, like, and share our videos. I'm Joe. Thanks for watching, and we'll see you next time.